We've got the Commission of Inquiry. Morning.
Good morning, ladies and gentlemen. We're about to start. Can we please request you to switch off your cell phones? Make sure of that. Thank you.
Mr. Shaskatsin.
Thank you, Chair. Today's witness is Advocate Elaine Harrison, who is the Director of Public Prosecutions in KwaZulu-Natal.
Thank you. Good morning, Advocate Harrison.
Good morning, Commissioners.
Are you going to swear or affirm?
I will take the oath.
Okay. Do you swear that the evidence you are going to give is the truth, the whole truth, nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you, Chair. Advocate Harrison, you should have in front of you a witness statement and a bundle, which is a letter that you addressed to Lieutenant General Mkhwanazi with a whole series of annexures. Do you have both of those documents in front of you?
I confirm I have them before me.
If we can start then with your witness statement. And first I would ask if have you read through that witness statement?
I have.
And can you confirm under oath that the contents of the witness statement are correct?
I confirm so.
Then if we go to the witness statement, if I can take you to paragraph 2, can you tell the Commission when you joined the NPA and when you became permanently employed at the NPA?
Thank you. I joined the NPA on 1 June 2000 as an aspirant prosecutor. I was permanently employed by the NPA on 1 December 2000. Throughout my career as a public prosecutor, I have held various positions.
Thank you, Advocate Harrison. I'm told I have to ask you either to move the microphone closer to you. Apparently there's a problem picking up the recording.
Thank you. Want me to repeat?
Could you do so? I'm not sure if it was
no problem, Counsel.
Recorded.
I joined the NPA on 1 June 2000 as an aspirant prosecutor. I was permanently employed by the NPA on 1 December 2000. Throughout my career as a public prosecutor, I have held various positions.
And then in paragraph 3 and 4, you talk about your appointment first in an acting capacity as Director of Public Prosecutions and then in a permanent capacity. Can you just give the Commission the dates?
I was appointed as the Acting Director of Public Prosecutions for KwaZulu-Natal during 12 May 2019. And then I was permanently appointed as the Director of Public Prosecutions for KwaZulu-Natal on 1 November 2019.
And in the correspondence that we see in the bundle, you sometimes sign documents using the name Zungu and later Harrison. Can you just explain that to the Commission?
At the time when I was appointed to act as the Director of Public Prosecutions in May 2019, I was still using my surname of Zungu. Thereafter, after my appointment, well, sometime after my appointment as permanently, I then reverted back to my maiden surname of Harrison.
If we go then to paragraphs 5 and 6, you refer to your carrying out of the mandate of the NPA and performing the functions and powers vested in you in that regard. Can you tell, if I take you to paragraph 6, can I ask you to tell the Commission what those powers and responsibilities are?
Thank you. I'll just read them out. In respect of KwaZulu-Natal, by virtue of my position and in terms of section 179(3) of the Constitution, read together with section 24(1) of the National Prosecuting Act 32 of 1998, I have powers and responsibilities as set out hereunder. 1, power to institute and conduct criminal proceedings and to carry out functions incidental thereto as contemplated in section 23 of the NPA Act. 2, supervise, direct, and coordinate the work and activities of all deputy directors and all prosecutors. 6.3, supervise, direct, and coordinate specific investigations and carry out all duties and perform all functions and exercise all powers conferred or imposed on or assigned to me or under any law which is in accordance with the provisions of this National Prosecuting Authority Act.
And then can I ask you also to read paragraph 7 of your statement?
I have always exercised the mandate of the NPA without fear, favor, or prejudice.
Now, we're going to get in some detail when we come to the correspondence to issues relating to the Political Killings Task Team. But at this point, can you just very briefly, with reference to paragraph 8, explain your overall view of the Political Killings Task Team and what value, if any, it had?
As the Director of Public Prosecutions for KwaZulu-Natal, I have considered the Political Task Team as an essential and necessary structure for the province of KwaZulu-Natal and the country as a whole. This is so as the team was precisely aimed at dealing with politically motivated and related crimes that gained momentum and threatened to destabilize the province and to spiral to other provinces.
Now, when did you first hear reports relating to the disestablishment of the task team?
During December 2024 and January 2025, I was on leave. So during January 2025, I then, through the social media reports, I came to learn about the de-establishment of the task team. And at that time, I thought that it was fake news. So I was on leave.
So you initially thought it was fake news. When you returned from leave, what did your opinion change?
After I returned to the office in January 2025, I was informed by Advocate Gaba, the dedicated prosecutor who's responding to the task team matters, that the social media reports may be well true because the team had been informed by General Kumalo only to continue with matters that had been enrolled or were waiting for decision.
Now, have you ever formally been notified of the disestablishment of the task team?
At no stage was any formal communication addressed to my office notifying us of the de-establishment of the task team.
I want to take you now to a letter that Lieutenant General Mkhwanazi addressed to you in May 2025. And that letter is at page 244 of the separate bundle that you have. So if you can go to 244.
Found it.
You're ahead of me, Advocate Harrison, unfortunately.
Sorry.
You have found it? No, no,
Yes.
I've now found it too.
Okay.
Can you, first of all, can you confirm that you received this letter?
I confirm so.
And can you read, it's a very
Let
short
us-
letter.
Let us name these, the file with the DPP's statement. Let's call that Harrison 1. And
Chet is already part of MK 12. So we have it on file. In fact, this bundle that Advocate Harrison has is MK 12.
I am actually, and I brought Kwanazi too, and I thought that's what we would refer to. And but I do see this small bundle here. So it's on that basis. It's on that basis that I thought you are going to be handing this up, unless we then refer to
The page numbers in MK 12.
In MK, yeah. If we do that,
The witness and I are prepared on those page numbers, so let's just keep it, if it's all right with you, Chair, then we can keep it, it's MK 12.
let's refer to the relevant MK then, yeah.
So on page 244, you've confirmed you received this letter from Lieutenant General Mkhwanazi. It's a very short letter. Can you just simply read its contents into the record?
Thank you. It's addressed to myself as the Director of Public Prosecutions in KwaZulu-Natal. It is dated the 22nd of May, 2025. It is headed Political Task Team, Prosecution Guided Investigation, Failure to Execute J50 Warrants. This office wishes to apologize for the failure in executing J50 warrants in dockets among 121 case dockets that this office has discovered to have been delivered to Pretoria due to a telephonic instruction received by the political task team leader. It is an unfortunate situation that this office became alerted on 2025-05-20 in a docket accountability session to the fact that all prosecution guidance since 25-03-26 has not been addressed. This office assures the Office of the Director of Public Prosecution that the whereabouts of these dockets is being investigated and the findings will be brought to your attention. Kind regards, and it's signed off by Lieutenant General, Provincial Commissioner KwaZulu-Natal, N.S. Mkhwanazi.
If we can then go back to your statement. First of all, can you confirm that this is the letter that you refer to in paragraph 12 of your statement?
I confirm so.
And just to go back to the chronology, this letter you've recorded was dated 22 May 2025. When had you first heard of the disestablishment of the task team?
As I've indicated, through media, it was floating on social media from about the 3rd of January.
So this was approximately 4.5 months after you first heard of the disestablishment or the alleged disestablishment of the task team.
That is correct, Counsel.
Now, you note in paragraph 13 of your statement that the letter did not refer to the disestablishment of the task team, but rather to the removal of dockets.
Correct.
And in paragraph 14, you refer to frustrations. When you received this letter, can you explain these frustrations to the Commission?
Thank you. Firstly, there had been no formal communication to me about the de-establishment of the task team itself, other than what I saw on social media. Secondly, Lieutenant Jerome Kwanaze had not addressed the de-establishment of the task team in his letter. He had referred only to the removal of the dockets. Thirdly, an enormous amount of work had taken place to ensure the necessary coordination by providing a dedicated prosecutorial team to address all the challenges that had historically been raised in responding to the work of the task team. And fourthly, news of the disestablishment emerged at the time that all of the work that had been put in was clearly bearing fruit, and the coordination was producing the desired results.
You responded to Lieutenant General Mkhwanazi's letter. If I can take you to page 195 of the MK12 bundle. Can you confirm that that was your response?
Commissioners, I confirm that this is my correspondence and my response to General Mkhwanazi.
And in paragraph 1, you refer to your correspondence dated 22 May 2025. Is that the letter from Lieutenant General Mkhwanazi that we just saw?
That is correct, Counsel.
Can I then ask you to read the first 3 sentences of paragraph 2 of your letter?
Kindly take note that the purpose of this correspondence is related to the issue of whether the political task team continues to exist. There have been a number of media reports whereby it has been noted that the political task team has been disbanded. Should I continue?
Sorry, and the third sentence?
There has been no formal communication to the Office of the National Director of Public Prosecutions, as well as my office on this issue.
And probably also the fourth, which emphasizes the point.
It is of concern that this office remains unsure of what the correct position is regarding the existence of this team.
Is there anything you would like to add, to elaborate on what you're saying there?
You know, there was a bit of frustration at this time because there had been a lot of work that had gone into responding and getting coordination from the NPA side in the province towards the work of the task team. So when I started off in this way, is because General Mkhwanazi had said nothing in his correspondence regarding the, in his letter dated 22 May, he had said absolutely nothing regarding whether you say disbandment or de-establishment of the political task team. And yet I already had information from the director who was, the deputy director who was heading the section. So you can understand the frustration that there was, and it was all on social media. Nothing was coming from him.
Can I ask you to go to the next paragraph where you refer to Advocate Xaba? Is he the deputy director to whom who you just mentioned?
Yes, he is the deputy director of public prosecutions, who is the overall portfolio holder for the political killings task team cases.
And what had he informed you?
Can I read what I've noted in the letter?
Certainly.
Thank you. I engaged Advocate Xaba regarding the contents of, that's just responding to that. Advocate Xaba had informed me, as I indicated, that he had informed me that what they had been told by General Khumalo was that they will only be dealing with the decision dockets that they had, and will also be dealing only with the court-going matters. They would not be taking in any new matters.
And then if we go to the top of paragraph 190, page 196, can you read what you have written there and explain the significance of it to the Commission?
In 2026, there will be local government elections. We are aware that all elections are often preceded by violent political activity. This consists of murder, attempted murder, assault, criminal injury, malicious injury to property, etc. being committed. The modus operandi differs in that it may involve members from the same political party against each other or between the different political parties. And the reason I say this is clearly in KwaZulu-Natal, we see that every time that there are elections, this is the norm that happens in KZN. And it was a forewarning that the next elections, which are going to be in 2026, that we can expect that there'll be some spike of political activity, violence within the province. And I was worried, as I said, I was worried at that stage that, and a bit frustrated that no one is coming out to tell me what is the correct picture regarding this letter that had now circulated in the media.
Thank you. In the next sentence of the letter, the next paragraph, you speak of being requested to provide dedicated capacity to respond to the political task team. Can you elaborate on that?
Upon my assumption of duty in the province upon my assumption of duty in the province as the Director of Public Prosecutions in May 2019, acting at the time, my office was approached by General Khumalo, who requested for dedicated capacity to respond to the political task team. Basically what had happened is that at that time, my predecessor had nominated Advocate Slepe, a Deputy Director of Public Prosecutions, to manage the portfolio. As the work increased, obviously then being on his own, he was unable to deal with all these political cases that were being brought to him. And as a result, General Khumalo was requesting for a dedicated capacity. In other words, he wanted a number of prosecutors to be allocated to specifically deal with these matters.
Thank you. You then refer to annexures to your letter, and we will deal with those annexures separately later. So if I can take you down another 2 paragraphs where you refer to a meeting on 5 August 2019. Can you tell the Commission of the relevance of that meeting?
The relevance of this meeting was that at that time, due to the numerous challenges that we were having within the province regarding just to get the coordination correct, there had been a meeting of 5 August 2019. And at this meeting, we saw that our National Director of Public Prosecutions was at this meeting, and there were several other dignitaries as well that was there. And if I remember, there were also, I think Minister Lamola was also there, because there's a correspondence further down in this bundle that talks to this meeting that came from Minister Lamola.
And what was what came out of that meeting, or what did the meeting decide?
It was decided at this, there were several issues that were basically raised at this meeting. And at this meeting, it was decided that we need to revisit ourselves regarding how we were working. And also, it was also one of the issues that was also discussed was finding a central court to deal with the political killing matters in the province.
Now, in your letter, you referred to a decision that the organized crime component, OCC, would be the dedicated capacity for the politically related cases. Can you tell the Commission what the OCC was?
Thank you. The OCC is the organized crime component, which is a unit that falls within the office. To basically describe the office commissioners, you've got my position as being the Director of Public Prosecutions, and then you've got underneath, you then have at senior managers of Deputy Directors of Public Prosecutions, and then senior managers also consist of the Chief Prosecutors. So every unit, we've got a few units there. We've got the General Prosecutions that will be dealing with your normal murder cases, and robberies, they can be organized sometimes, but the general murders. Then you will have, for example, the organized crime component, which will be dealing with the more syndicate type of offenses, organized crime, gang type of offenses, and respond to the POCA legislation. Then you also have the tax unit, that will be a specialized tax unit. Then you'll have the specialized commercial crime unit, and then you'll have the asset forfeiture unit. All these are headed by deputy directors of public prosecutions. And then underneath them, you've got advocates that then report to the deputy director. So they will deal with all the work. In other words, they are at the operational ground of the cases. So that is how it was.
And what informed the decision to allocate political killings to the organized crime component, the OCC?
At that time, I also wish to put this before the commissioners. Commissioners, at this time, we were really struggling within the province, and I think the NPA as a whole. There was just no recruitment taking place because of the austerity measures that were in place at the time. But I had to look at all the logistical issues. One, the outcry was there. Whatever we had tried to put into place was not working. So I had to identify a unit. And because of logistics, I decided I needed a unit in Durban because the organized crime component sits in Durban and the task team also sits in Durban, meaning that it would be easier for them to deal with the work. And also what I had at that time was some of the prosecutors within the organized crime at that time also had protectors. So we all know with some of these cases, they come with with challenges with regards to security for our prosecutors. But they also needed to respond to some of our organized crime nature criteria, if I can put it that way. And therefore, I believed at that time that they would be able to respond to the political task team.
Can I ask you just to elaborate on your reference to organized crime type criteria?
Okay, these are the cases which are organized in nature, and these are the ones that often involved the syndicates and the gang type of criteria that you would find, and also to respond to the POCA legislation. So there was it's really gang related, groups, syndicates operating. Though with their investigations, they always must try and look towards establishing whether there's a syndicate that is involved in their type of matter that they deal with.
And was there any overlap between that and the political killings environment?
I didn't see any overlap because I think at the end of the day, they were also looking towards determining whether or not these were syndicates that were operating or gangs that were operating. And it can be one or two, you know.
You then refer to further annexures, C, D, and E, and we'll get to them in due course. If I can take you over the page onto page 197, and in the second, third, fourth, and fifth paragraphs, you talk about the work that went into the political task team. Can you elaborate on that for the Commission?
Okay, thank you, Council. Basically, what happens is that I'll just read out the one paragraph because I think it explains it. The dedicated prosecutorial capacity is headed by a Deputy Director of Public Prosecutions who has advocates under his management who are assigned to guide the investigations, make prosecutorial decisions, and prosecute these matters where there are murder and or attempted murder charges. Adot, do you want me to continue with that?
Well, maybe you can, your next sentence refers to a database. Maybe you can just explain what that database is.
Okay, a database has been retained since the inception of this dedicated capacity, and there have been numerous successful prosecutions. There are several high-profile politically related matters on the court roll. The dedicated prosecutors continue to provide their prosecutorial dedication to these cases. However, they are also not certain as to what is the position regarding the existence of the team and the new cases reported. Database is a table, it's a document where we record all our cases that we've got within which the prosecutors are dealing with. So the database for the politically related cases was divided into three. You've got the decision dockets, those are matters not yet on the court roll. You've got matters on the court roll. The work that is being done by the unit.
And was there a
Or just-
database dedicated specific,
Or maybe continue with the database, I'll come in after that.
specifically to the political killings task team matters?
Yes, Council, we've got a database specifically for the political task team matters, just like how we would have for the other type of cases. For example, the drug cases, you will have a database for that. Environmental, you'll have a database, but they all fall under the organized crime components.
DPP, General Mukwanazi and General Masemula testified that there was a higher success rate in the prosecution of PKTT matters. We engaged both of them on that, and we wanted to get an idea on what exactly the comparators were. You don't necessarily suggest this higher success rate. You say you use numerous. There have been numerous successful prosecutions. Do you share their view that this was higher than the norm?
Chairperson, can I describe it in this way? If you look at our database with regards to the cases, the finalized cases, for example, in 2025, all the matters that have been recorded there are successful prosecutions. But we don't go and say, okay, but we also look at in the previous years, how have we been doing with regards to those cases? And we do find that we rate ourselves regarding, I wouldn't say always successful, but finalized because of the complaints that have been there regarding the prosecution of these matters on the court roll. But if you look at prior to the dedicated capacity and after the dedicated capacity was provided, you will find that there was a higher finalization rate of these cases and higher success rates of the cases.
Thank you, DPP.
Thank you, Chair.
Would those figures be available for this commission if we needed them?
Chairperson, I'm sure I can get those figures because we've got our databases operating.
Thank you. And then, of course, picking up on what you were saying, it would be useful to have a historical perspective as well so that we can do the comparative exercise.
Yes.
Advocate Chaskalson, can I just ask a question, please? Advocate Harrison, I'm assuming that dedicating specific capacity in terms of prosecutors and also a dedicated court had something to do with the finalization of these cases, because without dedicated prosecutors and dedicated court, these cases would be enrolled as part of the normal enrollment of criminal cases and they would have to wait in the queue. Would that be a fair assessment?
Chair, can I indicate that we never ever got to the dedicated courts? We did, there was an exercise, a series of meetings, a whole exercise that was conducted, but we never got to the issue of the dedicated courts. What the prosecutors did do is try and have those matters prioritized on the court rolls that they were operating from, so that we could see the better finalization of the cases. Thank you.
We were going to get to that later, but maybe you could explain to the Commission what the investigations into a dedicated court revealed and why you never got there.
Thank you, Council. Chairperson, at the time when there was this talk about the dedicated courts. And if my memory serves me correct, although I cannot be so specific, was that there was a real outcall from the time when I came in for a dedicated court. So basically what happened is that, especially after the meeting of 23 August, we then set out to look for a dedicated court. And we went to the acting regional court president at that time and spoke to him. But we realized that we couldn't speak without the regional head for the Department of Justice. So what we then did is we had the meeting postponed. And during the time when we had the meeting postponed, then we had the correspondence of the Minister Lamola come in about the dedicated courts. And that was the 10th of September, if I look into the record. And on the 12th of September, we then had a meeting with the regional head together with the acting regional court president at that time to discuss the dedicated courts. And this was also with my team that I was with. Chairperson, there were a series of meetings thereafter. And one will note, if it ever comes, is that there was a court, one court was identified, but there were security issues in regards to that court. So we had to go back to the drawing board. And then we identified different areas or different centers. And it was 3 basic centers. It was Richards Bay, it was Durban, and then it was Pietermaritzburg. And the reason for that was that we would be bringing the cases from the outer lying areas to the nearest center to deal with those matters. And Chairperson, we went deeper down with that analysis. We started to look at, okay, now let's look at the cases that we've got. And we found that some of the cases were, many, let me put it that way, were already on the court roll for trial. Now, witnesses have been subpoenaed, they need to go to that court. You're now just disorganizing everything in regards to those court rolls, because remember, it's already a set court roll for that court. But further than that, Chairperson, that something that also was a bit of a concern for us was that you've got a matter coming from, let's say, Engwavuma or Chozini, and you're bringing it to Richards Bay, which is nearly, say, between 200 to 300 kilometers. You're taking away a matter from the community where the matter was committed. The community also wants to listen to the matter. Further than that is that you've also got the family of the deceased that also wants to come in and listen to the matter in court. Now, there's no witness fees to pay for all these people that need to come in. So that was also something that we had to discuss. And that is the reason why at the end we just decided, you know, the matters are there on the court roll. They are continuing. It's not as if we did not go back and look at or look into the issue of a dedicated court, but just the logistics and everything surrounding the logistics was just not working out for us.
Thanks, Advocate Harrison. Can I take you back to your letter now? And we've essentially reached your conclusion. And can I ask you actually to read into the record what the conclusion of your letter to Lieutenant General Mkhwanazi?
It is requested that you assist with providing my office with a response regarding whether the SAPS political task team still exists. The dedicated capacity needs to respond to the dedicated task team. If there is no dedicated task team, then the dedicated prosecutorial capacity will be dissolved and all new cases will have to be reported to the chief prosecutors in the area where the crime is committed. This office cannot retain dedicated capacity where there is no dedicated SAPS task team. Your correspondence will assist us as the unit has to plan for the year 2025-2026. It has its own priorities as per the NPS AOP. As we are all aware, organized crime has become the new focus or priority, and this office needs to plan. I am unfortunately not able to complete the planning because the issue regarding the existence of the task team has not been communicated. At this stage, the only information which one has is that in the media. Your urgent response to the above issue will be appreciated and signed off by myself.
Thank you. And is there anything you want to say in, I mean, it speaks, says a lot itself, but is there anything you want to say in amplification of that conclusion?
Chairperson, the only thing is that, you've dedicated the work of the task team and you've given I've given the dedicated team from the organized crime component. And we all know that what is going on at the present moment as it's 2025 regarding the issue of organized crime. If you read in any media platform, you'll always find something about organized crime. And the NPA has got its own strategies and action plans as to how we need to approach the work. And I was finding that I'm unable to finalize the KZN annual operation plan because there's no finality regarding the existence or non-existence of the political task team, which would then it would have an input regarding the KZN plan. Thank you, Chair.
Mr. Chairperson, before you leave this letter, Advocate Harrison, if you look at page 196, that letter, and you've skipped parts, I just want to clarify that I understand them correctly just from my reading. In the third paragraph, you say, I also wish to bring to your attention a correspondence with the Minister of Police. And that correspondence, and this is to the National Director of Public Prosecutions, and that correspondence is the 24th of May, 2019. And then in the next paragraph, you discuss the meeting of the 5th of August, 2019. And I think in your explanation of that paragraph, you say Minister Lamola was also present at this meeting. What does this mean? In May 2019, you speak of Minister Cele, and in the next paragraph, in August, you reference Minister Lamola. Had there at this point been a change, or is it a mistake, your reference to Lamola?
Okay. Commissioner, in 2024, in May 2024, it was Mr.
2019.
In May 2019, it was the Minister of Police at the time, Mr. Cele, who had written to the National Director regarding the coordination process.
Yes.
And then there were a series of meetings. And when I say a series, there were lots of meetings at this stage. Then you have the meeting of 5 August 2019. And I think I indicated somewhere, I can't remember all the dignitaries that were there, but it was the National Commissioner of the South African Police was there. I can't remember whether it was Mr. Cele at that time or Sitole, but it was one of the national commissioners. But indicating that they were there, and if you look at the correspondence, as I said, from the Minister Lamola, he clearly was present at that meeting of 5 August. So it was me trying to explain or show the series of events that had taken place for us to get to the coordination process at the time.
All right. So what I wanted to clarify was in August 2019, the minister at that time was Minister Lamola. Oh, sorry, I'm making a mistake actually. Minister of Lamola was Justice, right?
Yes.
Yes, and Cele was Police.
Yes.
My mistake, I don't mean to confuse you. A different point about it though, in May 2019 and in August 2019, you had both Minister of Police and Minister of Justice concerned about political killings at that point and requiring them to be prioritized with dedicated resources.
That is correct, Commissioner.
And that's because at that point it was an issue, political killings in 2019.
At that point, it was an issue.
Thank you. Thank you, Mr. Chairperson.
Thank you, Commissioner. Maybe if we can now go to the annexures, and if we can take them chronologically, can we start with Annexure B, which is at page 202 of the MK12 bundle, and it's the letter from Minister Cele, and it's 19 May 2019. And before we actually look at the annexure, can I take you to an email on page 251 of that bundle? And is this the email under which you received the copy of Minister Cele's letter?
Yes, Council, that is the email that forwarded me the correspondence that is on page 202. And the email is dated 3 June, and it was received from the office of Advocate Batoy.
Then if we go back to the letter itself on page 202, in paragraphs 1 and paragraphs 2, the letter explains its purpose and sets out its background. And then in paragraph 3, the minister identifies challenges. And there are a series of challenges that the minister identifies. Can you take each of those challenges and just respond to them as whether they were challenges, whether you accept that they were challenges, and later deal with how you responded to these challenges?
Thank you, Council. The first challenge there was the Section 204 witnesses killed while in the witness protection program. I think it's only one case that was reported where this had happened, but it had an impact on the other cases. So if you look at it, one case it's recorded there, the station and case number, but it impacted on these other two, meaning that that witness was probably a potential 204 witness in the other two cases. Do you see that, Council?
I do.
Yes. So, and it was indicated that he was killed whilst in witness protection program. And the witness protection program is something that fell within the space of the NPA, but there was a suggestion that came from the political task team who responded that maybe they needed to get police officers or security to deal or to assist with that program, especially for their witnesses. Then the second one is key witnesses.
Sorry, Advocate Harrison, before we leave the first one, just for the benefit of the public, can you explain what a Section 204 witness is?
It's an accomplice witness. That is, I don't know if you want me to go deeper than accomplice.
I think accomplice witness should be good enough.
Okay, thank you. And then 3.2, key witnesses killed outside the witness protection program. It was justified by witnesses on the cases mentioned in the table below were offered with witness protection program but declined. Chairperson, this is not unusual, where witnesses are given an opportunity or are presented with the option of going on to witness protection and they decline the witness protection. If they are thereafter killed while outside the witness protection, obviously we can do nothing about it. We've offered them the services. Then Section 204, witnesses turned against the state, witnesses who abandoned witness protection. Let's differentiate, or let's try and unpack the two of those. A 204 witness turned against the state would be a witness where he has produced a 204 witness statement, and then he decides that he's no longer going to testify for the state. And then you have a witness who has abandoned the witness protection program, is a witness who was on the witness protection program and then decided to walk off the witness protection program. So that is how I would unpack that challenge. And that is also not uncommon. In cases we have this happen, where witnesses are taken to witness protection and just decide, I don't want to anymore. And I would like the commission to take this into account. When you put a person into witness protection, you're basically taking away a person from their home. You are taking that person away from their normal way of life and surrounding circumstances. It is not easy to be taken away from your home. So it is understood when witnesses abandon the witness protection program. They're not used to that lifestyle of having to be confined and also being moved away from your home for months on end. So we kind of like understood what the challenges were, which then calls for the prioritization of these matters in the court system. And then I've dealt with the issue of the witnesses who turned against the state whilst out on witness protection. You also cannot, counsel, you also cannot stop that because there are many factors that influence a witness turning against the state. And just to elaborate on that, the person is out there. They are vulnerable to being approached by the accused or whoever they're going to be testifying against. And we don't know what sorts of promises are being made to that particular witness. So these are the factors that could influence a witness turning against the state. The fourth, or where it says number 4, questionable withdrawal decisions by the NPA, and number 5 is questionable decisions by the NPA. Number 6 is speedy trials delayed. Number 7 is delayed decisions. Number 8 is accused granted bail while on accused granted bail whilst on bail. Chair, before I deal with the others, I want to go to the number 8. That's one. And
Certainly.
I think the minister's letter is very clear. It actually explains the issue of the bail. If you look at, for example, 8.1, it says bail was opposed on all cases, but it was unsuccessful, meaning that the prosecution opposed bail, but unfortunately, in courts, the bail was granted. And I've gone through 8.1 right through to 8.6. And in all of those cases, prosecution opposed bail, but bail was granted, except for 8.6, the last one. It is alleged that you have committed whilst on appeal. Chairperson, I haven't checked that specific one, but it would assume, I'm assuming that he was granted bail pending appeal, which is a norm, especially if a person has adhered to their bail conditions. But obviously, each and every case is decided on its own merits. So in regards to 8, it is explained regarding the accused granted bail whilst on bail. Then in regards, counsel, you did say questionable withdrawal decisions by the NPA. Chairperson, and withdrawals, questionable withdrawals, questionable decisions by the NPA. Can I deal with these two? Chairperson, this was brought to the attention of the NPA by the minister. I want to say this and make it very clear. It was also addressed during our meetings, with the series of meetings that occurred thereafter. This issue was addressed. It got to a stage, what had then happened was that we went, and I'll be very specific. On the 3rd of June, there was a meeting. On the 4th of June, the General Mkwanazi, at a meeting that we had with myself and my office, he did raise this issue.
Advocate Harrison, which year?
2019, Chairperson, 2019. So this memorandum, this correspondence is received from the National Director of Public Prosecutions. There are a series of meetings that take place. On the 4th of June, General Mkwanazi, in a meeting, he spoke about these questionable withdrawals by the NPA and decisions. What then the team and I went and did is that we requested for a list of dockets where they were concerned in, so that we could review the decisions that had been made by the prosecutors. Indeed, Chairperson, this was done. And we found that, in fact, the decisions that had been made by the prosecutors, they were justified under the circumstances. But what I do want to explain is that it was not only that, it actually led to some drastic step in that dockets had been opened against certain of the prosecutors regarding some of the decisions that had been made. Again, the process was followed of reviewing those dockets. And what we would do then is that we got the mother dockets, we got the dockets that had been opened against the prosecutors. We viewed these in conjunction. So you'll have to read the mother docket to determine and then look at the defeating. And in all of those, the decisions by the prosecutors were justified. Maybe it's the manner in which they had dealt with the matter that made the PKTT not happy regarding that, and then had opened dockets. Thank you.
What would that manner be? If the decisions themselves were justified, what would the manner be?
If the decision were fine, let me put it this way, Commissioner, what really should have happened is that they should have requested for a review of the prosecutorial decisions, what is often the process, rather than opening up the criminal cases against the prosecutors. And like one of them was the prosecutor had referred, I think, the matter for a diversion, and they were not satisfied with that, and therefore a docket had been opened. So we had to explain to them to say, we've got a review process within the NPA, and can we follow this process so that we are able to review the decisions? So it was just things like that, but it was also about communication and making them understand some of our processes within the NPA regarding how we would deal with these type of matters.
I'm looking at the years. The cases referred to here date as far back as 2012 and go up to 2018. So this is not about the integrated team involving the NPA, the PKTT. So this is pre the establishment of that integrated team.
That is correct, Chairperson.
Advocate Harrison, can you just explain, it may not have come across clearly, but when you say dockets were open, were charges actually lodged against individual prosecutors for the conduct, for their alleged misconduct of these cases?
Chair, there was no need to lodge any proceedings. The first step was, let's have a look at these dockets and determine whether or not they had in fact committed the offenses of defeating. And unfortunately, upon reading the dockets, the decisions made by the prosecutors were found to be justified. And this was a team that sat down and gone through a docket that consisted of a deputy director of public prosecutions, a chief prosecutor, and a senior public prosecutor. So they went through that, and the methodology I've just set it out. So there was no need for any disciplinary action. And once that process had been undertaken, Council, the final decisions and the report, they compiled a report that was submitted to my office. I had a look at the report. I was satisfied. It was quite a detailed report. I was satisfied with their findings, but I did have to report to the Office of the National Director because that had already been brought to attention, I think through one of the meetings, that there had been dockets that were registered against the prosecutors. So she asked for a report and I gave her the report. Thank you.
Thank you. If we can then leave the minister's letter and go to your directive dated, well, there are two copies of it. The one at 199 is dated 13 June. Can I take you to MK12, page 199?
I'm the counsel.
And that is a directive issued in your name, but if I can then take you to page 248.
I'm the counsel.
And if you go down to page 250, you will see it's a signed copy of the same directive.
Yes, counsel. That is correct.
And what was the date of the signed directive? Well, in fact, maybe I can assist in that regard. Can you go to page 246?
Okay. Yes, counsel, the directive is signed. It would have been signed on that date of, it's dated 21 June 2019, but it's the same directive. It's just that the one on that I attached to general, it had not been signed 21 June 2019, but it's the same directive. The reason I just changed the dates because I only sent out the directive to everyone on the 21st of June. So I circulated it within the province on 21 June 2019 with what you see on page 246, where I say this is to all the prosecutors, the management especially, dear all, kindly find the attached directive in respect of politically related cases for your urgent attention. and dissemination to all advocates and prosecutors in your respective units and clusters. And then it's the same directive, just different dates, because I didn't just change the date because I was sending it at that time. Thank you.
Thank you. Can we then go to the directive? And I've been working on the copy from page 199, so I'm going to refer you to that one. And first, can you describe the purpose of the directive? What triggered this directive?
Sorry, before that, Mr. Chaskalson, just to make sure we're on the same page, 199, my 199 is a directive dated the 13th of June. Are you saying it's the same thing as what is in page 248?
It's the unsigned copy of the version or we can shift to the one let's use the signed copy because that is the one that went out. They are the same document though,
Yes,
but for the
thank you.
signature and the date. Can you go to page 248, which is the start of the signed directive?
Found it, Council.
Sorry to move you backwards and forwards, but can you first explain to the Commission why you sent this directive out? What was its purpose?
Commissioners, as you will note, the directive, where we're working from, it's actually the same directive. It's just that it was dated the 13th of June and we were still looking at it. But I eventually signed the directive as per the date noted on the directive, which was 21 June, it was then circulated. The reason for this is, as I've indicated, Chairperson, between these dates, as you see, 21 June 2019, and the date of 24 May 2019, or let's say 3 June when I received the correspondence of the minister, there had been a series of meetings regarding this coordination. And with the team and myself that I was working with, we decided, because there had been a previous directive, that is why my one says, this directive replaces Directive 1 of 2018. Clearly, Directive 1 of 2018 was not bearing the fruits that it was intended to bear. And as I indicated, there was already a lot of work. So we needed to revisit Directive 1 and find another way to coordinate the work of the political task team. Therefore, Directive 3 of 2019.
And then can you take the Commission through your directive and just explain the rationale behind each provision of the directive?
Okay. Paragraph 1, this directive replaces Directive 1 of 2018. Then paragraph 2, KwaZulu-Natal has experienced a high level of violence, particularly against persons linked to political parties or perpetrated by persons linked to a political party. And that I literally just took from Directive 1 of 2018. And in order to manage the situation in KwaZulu-Natal, the Honorable President of the Republic of South Africa has convened an inter-ministerial task team comprising of JCPS cluster ministers to look into effective solutions aimed at eradicating the high level of politically linked violence experienced in our division. The Inter-ministerial task team will continue to visit KwaZulu-Natal until the situation can be considered to be under control. My office has to provide a comprehensive report to the NDPP on all these matters. That is just really governance. And then paragraph number 4, in addressing the complaints and challenges that have been brought to my attention with regards to 1, only 1 dedicated prosecutor in the province dealing with the matters. 2, prompt decision-making in these matters. 3, reduction of the withdrawals in these matters. 4, prioritization of these matters. And 5, a better collaboration between the chief prosecutors, the assigned deputy directors, and the SAPS task team. So if you look at just 1 to 5, it actually comes from the recommendations, the findings, made by Minister Cele in his letter dated 24 May, the recommendations that had been made in that letter, and also the meetings that had taken place that led, these are the challenges that are put in paragraph 4.1, which then necessitates, which then I say it has become imperative that this directive be issued in seeking to address the above complaints and challenges.
Can I ask a question about paragraph 2? Are you expressing there your view, or are you simply recording what Minister Cele had said at the time? Where you say KwaZulu-Natal experienced a high level of violence, particularly against persons linked to political parties or perpetrated by persons linked to political parties. Were you expressing your own view or simply recording what Minister Cele had said?
My view as well, Chairperson. At that time, you know, it's 2019, that also came, as I said, from Directive 1 of 2018. At that time, they were experiencing that, but the political cases had not stopped in 2019, so I couldn't leave that out. It was still, we were still experiencing a high level of political violence during 2019, and the case numbers will speak for themselves.
So if it was suggested in this commission that political killings in fact stopped in 1994, there were no political killings happening in 2019, what would your answer to that suggestion be?
I would say it's incorrect. There were political killings in the year 2019. Thank you, Chair.
Sorry, Advocate Harrison, I realized from your last answer before the question of the Commissioner that I cut short your discussion of the letter of Minister Cele. You, in relation to your directive and paragraph 4, referred to the findings and recommendations in Minister Cele's letter. Can I ask you to go to page 209? And again, apologies for jumping around. Page 209.
I am there, Counsel.
And are those the findings and recommendations to which you just referred?
Yes, those are the findings and recommendations.
And maybe if you can just go through those findings and recommendations, because they obviously informed your directive according to your evidence.
Okay. These are found on page 8 of the correspondence from the Minister Cele, dated 24 May 2019. They read as follows. The political related cases, especially murder, are organized in nature with different role players carefully identified, i.e. hitmen, spotters, coordinators, and individuals at the top who are ordering the hits. Number 2, most cases are dependent on Section 204 witnesses that were part of the syndicate, especially when the investigation has to be directed against individuals on top politicians and tenderpreneurs. The involvement of politicians and business people poses a threat of attempts to bribe the criminal justice system personnel. If it falls, then attempts to turn Section 204 against the state. If that fails, it should be, if it fails, then attempts to turn Section 204 witness against the state. If that fails, they kill the state witnesses, which results in the case being withdrawn. The lack of dedicated prosecutors to guide and prosecute on allocated cases. The trial-ready cases being postponed for a longer period due to unavailability of dedicated magistrates. The repetitive granting of bail to accused who are already on bail. Then number 10 deals with the recommendations. A dedicated courtroom for the processing of the politically related cases, dedicated preferable prosecutors and magistrates to deal with these cases, appointment of a permanent KZN, Director of Public Prosecutions, urgent appointment or utilization of police officials to fulfill the function of the security officers in the Witness Protection Program as prescribed in the Witness Protection Act 112 of 1998, Section 3, subsection 5A3 and section 6B. Yours faithfully, Minister B.H. Cele, Minister of Police.
Thank you, Advocate. And now if we can go back to your directive and to page 249.
Yes, Counsel.
And now can you take us through each of the elements of your directive? And at the end of each paragraph, maybe amplify what the purpose was and how you saw that instruction in the directive as helping to address these challenges.
The first one was number 5. All cases involving offenses either perpetrated by a person or persons linked to political party or against a persons linked to a political party must be considered by the chief prosecutor / delegated prosecutor before enrollment thereof. In potential high court matters, the provisions of Circular 3 of 2000 still apply. The chief prosecutor / delegated prosecutor must ensure that a complete copy of the dockets is forwarded to my office in the most expeditious manner in compliance with the 3-day rule, and the correspondence must indicate politically related cases in the subject line. I'm going to elaborate on this one.
Please do.
Okay. One of the things that the political task team with General Mkwanazi had requested was that we really needed a better coordination system. And if one went back to the history, before I came in as the acting director in May, there had only been one person that had been assigned to deal with these matters. And I think that is expressed very well in my correspondence of 10 June 2025. So when they asked for a coordination of these cases, we then responded to say, okay, because it's only one person and the matters are emanating from the different clusters, from the Durban cluster to Zuma cluster and everywhere, we decided that the chief prosecutors must be the first line of contact to deal with these matters. As a result thereof, it was decided that due to the, as I said, we were going through a time of austerity measures. We were not recruiting. So we decided that the chief prosecutors, because the matters are within their space, they must be the first point of contact. And hence, paragraph 5 of that correspondence. So that is what it was addressing, a coordination. Paragraph 6, maybe just to also just to take it a little bit further in regards to the docket copies to my office, it was also, remember that towards the bottom, I do say that the coordinator will be Advocate Slepe. It was for us, because when a matter is brought into our office, we open files. Therefore, this matter, every matter that was going to be coming in should be registered and must be within 3 days so that we are also able to monitor the progress of all these matters. So in the clusters, they'll have their database, but I will also have a database operating from my office regarding these political matters. Then the chief prosecutor delegated must interview the witnesses in these cases prior to the enrollment of these matters, especially in cases involving accomplice witnesses and single witnesses. Legible consultation notes must be filed in the B section of the docket. So before you enroll any of these matters, we requested that there must be a consultation with the witnesses, and this was to deal with the matter of cases being withdrawn. So one of the complaints is that matters are enrolled and then cases are withdrawn. But this was as a result of you only really consult with the witness when you're ready to go for trial. So to try and eradicate that with these type of matters, we then requested that before you even enroll, speak to your witnesses. That was to deal with the withdrawal issues that have been raised. So we try and reduce them. Then in respect of pending cases, the chief prosecutor or delegated prosecutor must interview the witnesses before a decision is made to transfer the matter to the regional or high courts. Legible consultation notes must be filed in the B section of the docket. This was to deal with 2 issues. The one issue is the withdrawal issue, And the other issue is the delay of the matter being placed on the roll for trial. So it was two-pronged to deal with those two in that regard. So we also don't have withdrawal of these matters. And then the decision to decline to prosecute a person and rather use such a person as an accomplice witness in terms of Section 204 of the Criminal Procedure Act 51 of 1977 must be made in consultation with the Chief Prosecutor and or DDPP in potential High Court cases. That would be the Deputy Director of Public Prosecutions. The provisions of Section 204 should only be used in exceptional circumstances where it is in the interest of justice to do so. See in this regard, Section D, Part 4 of the NPA Policy Directives, Section 204 witnesses. So this was to now deal with the issues that had been raised regarding the Section 204 witnesses, where we were just saying, before you decide on having a witness be a Section 204 witness, there are certain things that the Prosecution Policy Directive has put into place as safeguards, and they must have regard to those. Those are contained in the policy directives. And then the chief prosecutors and deputy directors of public prosecutions must ensure that a database of these politically related cases is maintained for the cluster or units, and that by the 10th of each month, one update for the whole cluster or units or offices is forwarded to the Strategy and Operations Office, attention of Mr. Sunil Prithipaul and Ms. Imelda Mgomezulu. So again, this was just for the governance issue so that we maintain the progress and we can monitor these cases as they're on the courts. No politically related case may be withdrawn without detailed and cogent written notes and reasons in the C section of the docket or DPP office file. Again, this was so that we monitor the withdrawals and the reasons that were provided for the cases that are being withdrawn by the prosecutors. And then the last one, Advocate Sleper remains the coordinator for these matters. And where there is a doubt in regards to a decision, he can be contacted for assistance. That was my directive, commissioners.
And if we then go to Annexure C, it appears at page 210. And do you recognize this document?
I recognize it, Council.
Can I take you to page 252, the foot of page 252, and will you confirm that that is how you received the document? At the bottom of page 252.
Yes, Chairperson, that is how I received it.
And would you just give read into the record the date of that covering email?
This is dated the 27th of August, 2019. It was addressed to myself at that time being Elaine Zungu. It is from Brigadier Dumsane Kumalo. This is now General Kumalo, and reports to the NDPP and National Commissioner.
And can you describe what this document Annexure C that starts at page 210 is?
Okay, this was a progress report. There had been a meeting on the 23rd of August, 2019, and this was a progress report regarding the cases for investigation and prosecution. And if I remember it's dated 23 August 2019. This had been presented at the meeting of 23 August 2019. We had then requested for copies of these so that I could then transmit to the office of the Advocate Batoy.
Thank you. Can I ask you to go down to page 218, where matters of concern are listed? Sorry, before you get to page 218, who did the presentation?
During the meetings, General Kumalo would do the presentation.
Thank you. And then if you go down to 218,
I'm there, Council.
and a list of matters of concern appears on page 218. Is there anything you would comment on in relation to this list?
Council, there's nothing much of concern except for the fact that it was just being reiterated, because if you read the paragraph above the matters, it's just that it's just to highlight that those matters were directed against individuals on top, like politicians and entrepreneurs who are mostly not directly involved in the commission. But the fact was there were 204 witnesses that were involved in those matters. That were part of the conspiracy or planning. So I think the concern is when you read that, it is these matters are like our 204 witnesses. Remember the challenge that had been raised, but in these matters, we've got 204 witnesses.
Thank you. And then there are on page, there are more matters of concern over the page on 219. Can you look at 219, and is there anything you want to comment in relation to those matters of concern raised at the in the presentation by General Kumalo?
Thank you, Council. Again, remember this is a meeting on the 23rd of August. And again, the issue of lack of dedicated prosecutors has contributed to the backlog of cases. So again, there was the issue of the coordination that was coming out again, despite the directive of 3 of 2019, there were still concerns raised regarding the coordination, the delayed decisions, whether to prosecute or not, also negatively affecting the turnaround time and finalization of investigation of these cases, the questionable decisions to withdraw the cases or charges against some individuals without valid reason, endorsement, and queries in the docket, the delaying of trial of an accused is pleading guilty, which leads to accused persons to be influenced otherwise and change their plea of guilty. The trial-ready cases being postponed for a longer period due to the unavailability of dedicated prosecutors and magistrates, reluctance to prosecute on single witness cases, dying declaration, child witness, and circumstantial evidence, the repetitive granting of bail to accused who are already on bail.
Do you have comments on these matters of concern raised by General Kumalo or Brigadier Kumalo at the time?
You know, when one looks at these concerns or matters of concerns as they've been labeled on page 219, you can see it. They were clearly coming from the part of the task team saying these are the concerns that we've got. These are the concerns that we have regarding these matters. And we needed to obviously provide, it is coordination. You know, when you read all of these, it's about coordination that was really a problem. Because if you look at these concerns, and if one goes back to the different meetings that we had during case progress or any meetings, these are the similar concerns that have been raised. Then you go back to the letter of 24 May 2019. Again, these are the concerns that were there. And then I go back to the issue of the prosecutors had made decisions, and then they felt they were justifiable decisions. But I think the team still had concerns even regarding those decisions that had been made by the prosecutors, which then my office decided, let me get a team to review the decisions and to determine whether or not the decisions taken were in fact justiciable or not. And we found that they were in fact correct decisions.
So am I correct then that some of these matters of concern you would accept as legitimate matters of concern? Others you would say were concerns that were investigated and proved not to be justified?
I would say we're concerned, it's two things that we need to do. There were concerns that, to me, were concerns that needed to be attended to.
And can we list those?
And those would be the lack of the dedicated prosecutors, because it was, it kept coming up and again, it kept coming up and again. But you see here, it hasn't been elaborated on, like how we would elaborate when we have a meeting. So it was just point. So as I can say, lack of dedicated prosecutors, what they wanted versus what we had provided to them, they were still not happy with what we had provided. And they listed their concerns regarding that. And that is the reason why at the end, it was decided that the organized crime units be the dedicated capacity. The delayed decisions, whether to prosecute or not, I would say, yes, sometimes one may view a decision as being delayed, but when you go into it, people are asking for information relevant for them to be able to determine, do I continue with a prosecution in this matter? Do I enroll the matter? So my understanding is that they may find it as a delayed decision. I would find it not as being a delayed decision. So the views are different depending on which, are you part of the prosecution or you're part of the SAPS. But mine has always been, objectively, let us go back into the dockets and look at what is continuing in the docket. So the questionable decisions, I've addressed that. We went back and we did our review. So we were fine with it. The reluctance to prosecute, again, one has to determine, it's a prosecutorial decision. You know, so some of them I didn't believe that from our perspective, but obviously it was clear that a dedicated capacity was required where they will sit together. Because remember, in the lower courts, they don't sit with the investigating officer. You direct the investigations in the investigating diary. When you've got the units do the prosecutor-guided investigations, which follow a different methodology, but it doesn't stop any prosecutor. I think that is what came to reality, was that the task team wanted that sort of scenario to apply. Thank you.
Thank you. If we can then go to the next annexure, Annexure D, which was a plan and strategy document presented at the 23rd August meeting, that appears at page 223. And again, just to track when you received this document, if we can go to page 252.
Sorry.
And if we scroll down to 52, sorry, yes. Sorry, can we just scroll a little bit further up so that we can get the date? And there you'll see an email that you, in fact, emailed out to Advocate Batoy at head office, copying a series of other addressees, where you attached a presentation that was done on August, at the meeting on the 23rd of August. Is what was attached the presentation that we see at page 223?
I'd like to correct just one thing. Maybe my correspondence needed a bit of just a correction, one correction, because that's the exhibits dated, the one on as Annexure C. It says the meeting of 23 August 2019, Annexure C.
That's a report, as I understand it, from that
No,
meeting.
That's a report at that meeting that was presented to that sitting of 23 August. It's just, it was presented at that meeting. Then from this report, it led to Annexure D. So if the presentation was done and then this report was then presented.
Can I just put to you that I think it's the other way around, that the presentation is Annexure D, it's sort of in the form of a presentation, and the report is Annexure C. But I may be wrong.
No,
in that
no,
respect.
no, Chairperson. I think I would have, the Annexure C was presented at the meeting of 23 August 20, and it still lies, you can see it still indicates the challenges. Then from that meeting, remember this meeting is now attended to by the National Director as well, and some of the, I think it was the National Commissioner who was there at that meeting of 23 August. It led at that meeting, they then said, you need to go back as the task team and as NPA. You sit down and you come up with an integrated strategy. So this was not presented at that meeting, my apologies. It came after the meeting of 23 August. Really, my apologies for that. So we went back, we sat down with the task team. We had to sit down. The directive was, you sit down and you come back with an integrated strategy. So we don't want NPA having their own documents. We don't want the task team having their own documents. We want one document from both of the teams. And that is when we went back with the team. We then agreed that we'd have the OCC as the dedicated capacity, and OCC then became the dedicated capacity. This was as a result of the meeting of 23 August 2019. And this document was then developed between the task team and my office.
And this doc, if we look at the page on screen at page 224, that sets out the purpose of the document.
That sets out the purpose.
And maybe if you could read that into the record.
Sorry, Council, maybe just to also indicate, if you look at the emblems on the documents, it's got the emblem for the NPA and the emblem for to show that it was now joint. Okay, this strategy is to provide an integrated framework within the JCPS cluster led by the South African Police Service and the National Prosecuting Authority in the detection, investigation, and prosecution of politically related cases in order to mitigate all the risk factors associated with investigation and prosecution of these cases in KwaZulu-Natal province.
And as you've just emphasized, this was a coordinated plan put together not by task team alone, but by task team in coordination with NPA.
That is correct, Council.
And you say this was pursuant to a meeting of 23 August 2019. And
that is pursuant to that.
When was the presentation itself made? This one now. The joint presentation.
Chairperson, I think that is when we then had the meeting of 5 August. It would have been then presented to the that meeting of 5 August 2019, because this is 23 August. The next meeting took place on 5 August 2019. So in
September.
between.
Do you mean September?
September.
All right.
August, September.
September, all right. Thank you, DPP.
Thank you, Chair. There are so many dates.
Maybe if we can clarify one of the dates by going to Annexure E, which is a letter, and if we go down, we will see it comes from the Minister of Justice and Correctional Services. and it's addressed to the Director General of the Department of Justice and Constitutional Development, which is a slightly different department. But it refers to the bilateral with the NDPP on the 5th of August 2019. And what was that bilateral? Who were the bilateral parties?
In that meeting, the bilaterals would have been the Department of Constitution of Justice and Constitutional Development. But I note that the minister signed it as the Minister of Justice and Correctional Services. That's how it's written there. So that was one. The National Prosecuting Authority was there, and the South African Police Services was also there at that meeting.
Thank you. Chair, would this be a convenient time to take the break?
Definitely. Let us, sorry. Or page for the record, Annexure E is at page 243.
243, Chair.
Yes. Let us adjourn and resume at 11. My co-commissioner doesn't like to lose a minute of the break. Let us resume at 11:17. Yes, Mr. Shaskelson?
Thank you, Chair. Advocate Harrison, if we can just go back to page 243 where we were before the break.
Yes, Counsel, I am there.
I'm just waiting for it to come up on screen.
Wow.
And there you will see that in the minister's letter, he refers to the recommendation about a single court for the PKTT matters, and we've discussed that already. In his second last paragraph, he says, I'm also in engagement with correctional services to find a correctional facility where all inmates who are on trial for the above-mentioned offence can be housed. Did this ever happen?
Chair, Commissioners, I don't think this eventually was successful because my recollection of what's going on is that they are housed in prisons nearby where their trials are proceeding. So I don't think there was any specific correctional facility that was ever found for just them specifically.
Thank you. And of course, if the single court idea was not implemented, then correct me if I'm wrong, but it seems that it would not make sense to have a single correctional services facility servicing courts scattered across the province.
Yes, that would be correct because the courts would then, yeah, that would be correct.
If we can then go back to to your statement and paragraph 23, and you've been describing attempts to provide better coordination around political killings. Did those have a positive result?
Commissioners, that is correct. The documents which we have just referred to as Annexure D, and once we had dedicated capacity from the organized crime component, which is now responding to the political task team, it seemed everything was then put into place. We're not saying there weren't any further challenges that may have been found, but that was the coordination that yielded the results that were being requested for.
And at what stage did you start seeing results from the coordinated strategy?
I would like to benchmark with the COVID, as I've referred to in paragraph 23, and maybe can I just maybe read out what paragraph 23 says, Council? Thank you. The interventions discussed in my letter were introduced in 2019. Prior to COVID, increased efficiencies were already visible. COVID then interrupted matters in 2020, but by 2021, it was clear that the improved coordination of these matters was producing speedier enrollment and finalization of political murder trials.
Can I ask, you talk about by 2021, was that state of affairs sustained going forward from 2021 through to 2024?
It was sustained.
And in terms of the practicalities and the efficiencies of the system that you had in place, did you see any need for the disestablishment of the task team and the disestablishment of the system that you had in place?
Council, I did not see any need for it.
Can I take you then to paragraph 25, where you say that the most important innovation that improved coordination was a single dedicated unit within the KZN NPA with dedicated capacity to handle all political killings case, which allowed for prosecutor-guided investigation. Can you explain to the Commission what prosecutor-guided investigation is, and maybe amplify what you say from paragraph 26 onwards.
Prosecutor-guided investigations is a methodology that is used by, it's used within the space of the National Prosecuting Authority, working closely with the South African Police Service. Here, it's basically where it is used mainly in the units because they have a particular methodology which they use regarding, and it's practical for them as well. So the police and the prosecutors sit down together, or and then they go through the case. They guide if there are investigations that are outstanding. The investigations are then guided, but you sit down together in a room and you discuss the dockets, and you are all in agreement with regards to the investigations that still need to be conducted. The document that can be kept, and in this instance of PGI, there's a specific document that is used. It is signed off by the prosecutor and the investigator, which is then to show I am in agreement and we agree that this is what needs to be done, and by which date. So there will be actions, and then they give a date when an action needs to be done. So that when you come back for the next case progress meeting on that specific matter, your guiding document will be your PGI document.
And how did PGI, or maybe if I can refer you to paragraph 27 and 28, can you explain to the Commission how PGI operated within the context of the organized crime component in the PKTT?
Thank you, Chair. Upon an engagement with the deputy who was in charge of this portfolio, he has explained it, and we've seen it also happen, whereby before, when a case is first brought by the political task team, what happens is that they have a case progress meeting. At this case progress meeting, they also introduce or present cases which are new, so new cases on their database. They will present these cases in that case progress meeting. What then will happen is that they will guide the investigation at that meeting. Once the investigation is about, let's say, 80% to 90% finalized, what then happens is that that particular docket is then brought to the offices of the organized crime component. It is registered in that office. It is then allocated to a prosecutor who then starts dealing with the PGI that we've been talking about to finalize whatever investigations needs to be finalized. And that is how they began working, and also just so that the investigations gets fast-tracked. And the good system about PGI, it holds you really accountable, because you sat there at the meeting and you said, I could do a specific action by a specific date. So why have you not done it? So this is the good system, the methodology about PGI.
And can I take you to paragraph 28, where you discuss some of the particular advantages in this PGI context of the facilities at the disposal of the PKTT team?
Thank you, Counsel. So after registration, the prosecutor allocated with the docket peruses the dockets, and thereafter meets with the investigating officer, and they discuss the remaining investigation which needs to be conducted. This is also noted and agreed upon. As the PKTT has a multidisciplinary team, the investigations can be finalized at a faster rate. For example, ballistics, cell phone analysis, tracking of suspects and or accused, and profiling same. Counsel, can I just maybe elaborate on that?
No, please do.
I want to take you now to Annexure D, the functionaries that I'm talking about. That is page 223, Commissioners.
Maybe before you take us there, let's just confirm that date that you were referring to. So remember, you said Annexure D came after Annexure C. So just to confirm that on page 225, bullet point 1, 2, 3, 4, 5. So that bullet point confirms an earlier briefing, which suggest then that this document came after that earlier briefing,
Yes.
right? And then you can move on to the point you wanted to make.
Now, this, if you look at Annexure D, page 223, I'm going to take it to, Chairperson, this copy is not, maybe, I don't know if they can put it there on the,
It's only the cover page
I do
that is
have a
not
clearer
all that
copy.
legible, and also the top parts, the headings. If you remember the headings, you can just tell us what they are. Oh, sorry.
Page
Oh,
8.
Gosh,
Page 8 of that document, it talks to
Okay.
investigation.
Chair, that's
is that
230.
229,
Yes, page 230.
230, or 230, or the next one, the next page. Yeah. What should we do, Mr. Chairperson?
Advocate Harrison was going to take us through this page, if it's possible for her to read it.
I will read it out, Chairperson.
Sorry?
I will read it out
Oh,
so that there's an understanding where I'm trying to go to with it. On my paragraph 20, I'm now responding to paragraph 28, where I talk about, as the PKTT had a multidisciplinary team, the investigations could be finalized at a faster rate. And if you look at page 8 of Annexure D, which is now on page 230, at the bottom of that page, Chair, Commissioners, it gives you the functionaries that there were from SAPS. The first, and those are the many at the
Are
one.
you referring to the 8 blocks right at the bottom?
Yes, yes. Those were the functionaries. Remember, this is our documents now that we've developed so that we can work and
I
address
see
all the
The
issues.
first one is forensic something.
Forensic team,
And the next one, intelligence, I think.
team, combat team,
Combat. Call data analysis, something.
call data analysis team,
My eyesight is not that bad. And digital something.
analysis team,
And ballistics,
ballistics team,
operational, what?
analysis team. And then the last one is the operations support team.
Would it be possible for you to explain what these teams mean? I mean, what different teams do and why it's useful to have them all in one overarching team?
Chairperson, I will request that this specific, these are functionaries that fell there. I do not know all of them, but the issue of like the call data analyst team, that would be important for our cell phone record analysis. Our ballistics team, that would be important for our ballistic analysis reports. Intelligence team would be for the tracing of suspects and accused. I would really leave this because this, if you look at it, that was for, that came with the task team, the PKTT. My team is described on page 9 of that, which is page 230 of the documents before us.
Not 230, not 231.
Sorry, 230 of the document.
231 I have
231.
for page 9.
231, sorry, chapter
Yes.
231, which is the next page.
Yeah.
That explains the prosecution team that we were coming with to respond to the task team.
So I see at the top, it's Major General S.D. Kumalo and Advocate Govender. Alongside each other at the same level.
Yes, Chairperson.
And can you just speak to Advocate Govender's role?
May we make this request, please? Can we be given better copies after the testimony?
Well, not immediately after, Chair,
no,
but
no,
we
no,
will
no,
source
no,
them.
no. Yes, yes.
Absolutely, Chair. We will
Thank you.
get legible copies.
Advocate Govender.
Indeed.
Advocate Govender is the Deputy Director of Public Prosecutions. She, at the time, was heading the organized crime component until Advocate Gaba was appointed. But before him, there had been an Advocate Mashamaide. But at the time of the adoption of this, it was Advocate Govender. Now I've got Advocate Gaba, who is now heading the portfolio.
Thank you. And then can you describe the rest of your team?
The rest of my team was made up as follows. Remember, Advocate Govender is now the dedicated capacity. So she is now responding with her prosecutors to the PKT team. Then it had been agreed upon that any other parallel matter would then go back to the clusters being the chief prosecutors, and they have their own structure within the clusters. So that's how we would operate, but the dedicated capacity was given to the organized crime component. And that is explained, our prosecutorial role is explained on page, well, it's contained there on page 231. Just the structure going down.
And if we go back to your statement and the point that you made that you had these different almost specialized capacities within the task team. Can you just explain to the Commission how that helped us? Can you contrast that with a situation where that specialized capacity in one place doesn't exist, and what happens when the specialized capacity is not in one place?
When you've got specialized and dedicated capacity, then turnaround times are faster. The work is dedicated. They solely focus on that work. And as soon as you start taking away functionaries, then there are delays. And that was one of our concerns, was the functionaries. I think paragraph 29, Council, if you look at it, I explained it very well in that paragraph.
Maybe if you can read paragraph 29.
Since the de-establishment letter of 31 December 2024, Advocate Gaba, who is the DDPP holding the portfolio in the OCC, has reported that the PKTT no longer has all these functionaries, and this is affecting their investigation turnaround times, resulting in the decisions now being delayed. This is a concern because when the whole process of requesting for dedicated capacity was made, the PKTT and the minister had complained that the prosecutors were taking too long to making decisions, and this had then been corrected. Now the functionaries are taken away, and now there's a delay with regards to investigations.
So now, with functionaries away, how do you get a ballistics test done or a cell phone analysis done?
It will then go back to the usual manner in which we've been dealing in, wherein we'll just have to wait until the ballistic report is produced. Whereas while we were working with the when the functionaries, all the functionaries are in place, when the exhibits, how they were working is that when the exhibit is recovered, the normal process of ensuring that it's allocated the SAP 13 number, booked into the SAP 13, taken out, taken immediately for ballistics. Now it means because the functionaries are not there for those who have been charged of that, it means it has to wait for someone else, be booked into the SAP 13. Then someone else will have to come at a later stage to book it out of the SAP 13, then taken to the ballistic unit, then wait for the time when at ballistics. Whereas if we had this coordination, you've got someone specifically allocated to look after that function.
Advocate Harrison, if I may, this concern that you register now, that since the functionaries are no longer available and it's the impact of prosecuting these matters, that concern would be addressed now that the dockets have been returned. Does it follow, have been returned to KZN or to the PKTT, let me say?
This impact started before the dockets were even taken. So what Advocate Gaba reported was that there were some functionaries. So after this whole letter now that was in the media, and he's in consultation with General Kumalo, is that it also was that the PKTT was no longer having all the functionaries that had been there before this de-establishment letter. So some of them had now been removed.
Okay. Well, I mean, from the evidence that we've heard, the instruction to disband was not implemented, other than the removal, the instruction to remove the dockets. That's what I'm trying to probe, that you would have had that problem, even though the instruction was not given effect to.
I think, Commissioner, that will be testified on more by General Kumalo, but this is what I received from Advocate Gaba, who works closely with General Kumalo, to say, this is the impact that we are now having, that we do not have all the functionaries within the, so our matters are going to be taking a little bit longer.
If we can just develop that theme and go to your paragraph 30, where you talk about your internal response to the 22 May letter from General Mkhwanazi about the removal of the dockets. Can you explain to the Commission what you did and what was reported to you?
Okay. After the correspondence of 22 May 2025 from General Mkhwanazi, I approached General Gaba regarding these cases. He advised that all PKTT cases which were not in court had been taken from them and that the unit was left with the court-going cases only. This meant that there was no prosecutorial guidance on investigations which could proceed on cases not in court. Effectively, this meant that the prosecutors were dealing only with the PKTT cases that were on the court roll.
And can I just ask you to explain that in some detail? If I understand, the whole model of prosecutor-guided investigation presupposes that the docket is essentially under the control of the prosecutor in some respect. The docket, or the investigating officer and the prosecutor work in coordination, and the investigating officer has the docket. Sorry, you just nodded your head.
Yes, that is correct, because remember the dockets is the property of the SAPS.
Of the SAPS, not the NPA. But of course, if the investigating officer no longer has the docket, that model can't work.
It means there's no investigations that can continue, especially regarding the matters that were not on the court roll, including matters that were on the court roll, but maybe there'd still been some investigations that were still required to be finalized. Because you must remember with these matters, it's not that a matter will always be a decision matter. In some matters, there are straight arrests. Therefore, the matter gets gets enrolled, and then the investigation takes place. Although the preferred methodology is to investigate and then arrest. But we did have cases which were on the court roll, but there were still some investigations that were outstanding. For example, I would say, like, let's say a ballistic report is outstanding, or a photograph album is outstanding, but the evidence implicating a accused to the commission of the offense is there, all of it. It's just this little evidence just that is outstanding, or something, but most of those were on the court roll.
Well, maybe you can illustrate with respect to paragraph 31. And for the benefit of those of us who are not familiar with the sort of serial numbers of documents, can you also explain in that context what a J50 is?
A J50 is a warrant of arrest. That's it, basically what it is. And where we're saying that we want a straight of arrest of this person. And basically, what then happened is I was further informed that there had also been dockets removed, which had J50 warrants issued, but which had not yet been executed. So in other words, what was left here was simply for accused to, for the police to go and execute the J50. That was all that was outstanding. Have the matter enrolled and the case be, and we take the matter forward. So some of these, the matters the dockets had been removed, meaning that they couldn't execute. We had to wait until the docket comes back before the J50 could be executed.
And then in paragraph 32, you confirm that indeed happened.
Yes, after the return of the dockets from Pretoria, a J50 was executed on one of the PKTT matters, and the matters was enrolled. If my memory serves me correct, Council, about 2 weeks ago or a week ago, we had this, one of these matters put back on the court roll. I just can't remember the court dates, unfortunately. I didn't prepare for that one.
And what is the current status quo?
The current status is that the prosecutors are now still working with the task team on guiding the investigations in the case dockets, which had previously been taken away. But I just want to indicate we've lost approximately March, April, May, about 3 months, 2 months of investigations being conducted.
And is that the duration of the time that you did not have access to the dockets? That's
the duration of the time. I just didn't get the exact dates when we started to get back. Remember, they would have been returned back to SAPS. From there, they would have then, or to the task team, or I don't know. Then from there, they would be returned back to the prosecutors. So we've had some time lost. And why I say this is, I want to bring to the attention the letter of the Minister Cele, where one of the things that he was complaining about was the delays in regards to these matters. Now, because of the dockets being taken away, exactly what Minister Cele was talking about at that time, we see it now happening during this time. So we cannot be held responsible for this delay now, because we are not responsible for these dockets being taken away.
In response to Commissioner Baloyi's question, her last question, you said that some of the members of some of the teams within this coordinated or integrated team had since left. Now you say the integrated or coordinated process is back in force. Does this mean those team members that had left are back or not yet?
Chairperson, I'm not yet sure about whether all of them are back. I cannot respond to that. I didn't query that, whether, and let me just say, I didn't query whether everyone is back. I think for me at this stage was, we need to get the work going. That is all I need, is let's get the work going. We've lost time now in these matters, and we owe certain people or victims responses to these matters. Let's get the matters going. Thank you, Chair.
If I can just put some dates to you. The evidence has been that the dockets were taken to Pretoria in 2 stages, on the 28th of March and the 22nd of April, and that they were returned on the 18th of August. So it would have been 3 to 4 months that your system was interrupted.
That is correct, Council.
If I may, and in the time that the dockets were removed, there had been, until they were returned, there had been no engagement from head office with your team of prosecutors in respect of the matters that they were involved with.
Chairperson, Commissioner, sorry, when you say head office, our head office or SEPS,
No, I'm saying with your prosecution team that had been part of this integrated team.
yes,
The dockets are now at head office, SAP's head office, sorry.
Okay.
At SAP's head office. There was nothing.
there was nothing. There was, Commissioner, there was no engagement by SEPS national office with the dedicated capacity within my unit, within my office.
Advocate Harrison, you previously said that no one consulted with you prior to the decision, if the apparent decision to disestablish the task team. What would your position been if anyone had consulted you prior to taking such a decision, or for your views on whether such a decision should be taken?
You know, after everything is said and done, and everything that went into providing the coordinated approach and providing this, coordinated team, I would have strongly motivated against the de-establishment. If I had been approached for a comment, I would have.
And why?
Because it showed that it was working. At that time, it was very, it was very evident that the team was working well, and to de-establish it would both be counterproductive and also destructive of the vast amount of work that had gone into shaping the system and the structures that were now working well.
And can you just repeat for us what structures were the structures that in your view were working well?
The structures, that's the coordinated approach that was now between the PKTT and the dedicated capacity that was there. You can see even today, they are still working well and they continue to work well.
In paragraph, the last paragraph rather, of annexure MK9, I know you probably do not have that in front of you. That's the letter by Minister Mkhunu dated 31 December 2024, addressed to the National Commissioner of Police, General Masemula. In the last paragraph of that letter, the minister says, "My observation is that the further existence of the PKTT is no longer required, nor is it adding any value to policing in South Africa." So based on the few responses you gave just now in response to Advocate Chaskalson, you do not agree with this?
I do not agree with that, Commissioner.
And as you sit here today in
I'm
this...
sorry, did I give the
sorry,
page
Chair.
number? Did I give the page number? Annexure MK9 starts at page 185, and what I read is at page 186. Thank you, Mr. Chaskalson.
And Advocate Harrison, as you sit here today, has anyone given you any formal indication of what the status of the task team is today?
Council, I still do not know the status. We continue to operate on the premise that there has been no de-establishment of the task team.
Thank you, Advocate Harrison. I don't have further questions well, for you.
Thank you.
Now, I'm not sure if the commissioners would like to put questions to you.
Just one for me. Advocate Harrison, the letter the chairperson is referring to is on the screen. The relevant paragraphs are the last two paragraphs, and the heading is 3, Political Killings Task Team. And you will see from that letter that the minister says he has made certain observations and he has decided, or rather directs, that the task team be established immediately. Now, assume for a moment that it was competent for the minister to disband the task team. Would you have expected that be done immediately, or what would have been your expectation, knowing what you know about the task team and its work?
In my opinion, Commissioner, you've got a system that is working. And if that is what is intended, you know, when you say the word immediately and you go and you look up the word immediately, it's today, pack up your bags and go. You can't do that. We are victim-centered as NPA. We would have probably requested for some time a continuation, because we've invested even not only in, it's not the victims, but our witnesses. We develop a rapport with our witnesses, who develop a rapport with regards to investigators, even bringing them to the prosecutor for consultation or for trial purposes. Now, when you say get up and go today, it's you leave everything. The better process was, let's sit down and let's try and find a system which will work for the benefit of ensuring that the interests of justice are always maintained, and we look after our victims and we look after our witnesses.
So is it fair to say you would have expected a proper winding down process that takes into account victims, ongoing cases, and ongoing investigations, including those cases that are on the roll?
That is correct, Commissioner.
Thank you, DPP. Thank you very much.
Thank you, Commissioner.
For the record, Mr. Shaskalsin, it has been reported to us that the issue of General Kumalo appearing in court on Monday, Magistrates Court, has been resolved with regard to his appearance before us at 9:30 on Monday.
Yes, Chair, I have, I have consulted with both the prosecutor and his legal team, and I understand that it has been resolved.
That is the position. Thank you very much. Let us adjourn and resume at 9:30 on Monday. Let's adjourn.